Good morning, everyone. My name's Pam Howland, and I'd like to welcome you to Ground Rules Employment Law over your coffee break. I'm joined here today by Jennifer Walrath, and we have a special guest today, Jennifer Hooft with Hire Resources. Jennifer is an HR consultant, and we have worked together for many years now. I believe we're bumping up on 2 decades of working together, collaboration on different employment law issues and projects. Today, we're taking on a really hot, right off the press issue. We're talking about the executive orders we have seen in the last week that relate to diversity, equity, and inclusion programs and initiatives. We have spent the last week thinking about it, wondering, analyzing, and we know that you out there all have questions just like we do as to what does this mean and what will this change in the workplace? What are the issues? What are the considerations? And while this is unfolding real time, we don't have all of the answers. And the one thing I would say on the front end is stay tuned on these issues because it's going to change, develop. We'll see more guidance. We'll hopefully have more resources as time goes on. And undoubtedly, we're going to have a bunch more issues that probably come down the line here too. But today we want to jump in and talk about these executive orders, what they mean, and considerations for employers. So I'm going to turn it over to Jen Hooft. It's a little confusing today because we have Jen Hooft and we have Jen Walrath. So we'll do our best to make sure you know who's talking here. But I'm going to turn it over to Jen Hooft, our guest, and see what's on her mind and what her reaction is to these executive orders on DEI.
Thanks, Pam. So I think this is alarming for many people who are practicing human resource management or for employers who are trying to navigate and understand what this actually means on the day-to-day for them. And so one thing that pops out to me is even though we are hearing DEI needs to change or be modified or even go away in some respects, we also know that much of this is baked into the way that we do our work. So in other words, we have employers who for many years now have engineered their talent acquisition processes, their compensation approaches, their promotion and assignment opportunities in a way that provides equity in terms of who gets to play, right? So we are very purposefully wrapping it into the way that we do our work, and I don't think any of that has to change. For instance, if you're working in talent acquisition, you are often qualifying applicants against your job description requirements without any regard to who the candidate is, what aspects of their personhood are considered, but just really rather whether they can do the job. That's what's important. Often job-based compensation systems are used where it just matters what you're doing on the day-to-day. That's how you get compensated. It isn't about who you are as a person. It isn't even about your personal skills. It is about the duties and responsibilities of your job. So I think those are a couple of things to think about that those don't really need to change. I think what we're seeing in these executive orders is that if people are given preference based on anything to do with their diversity, or if there are set-asides, say you have a policy that says, well, if we have a tie and we're looking at promoting someone, we're going to give preference to a specific class. Those things would be, it seems, problematic under the new guidelines.
Yeah. A couple of thoughts on that. That's a really good point. I think what we have been talking about is most of our clients, I would say really all of our clients. I don't really have any clients I know of who have set-asides, quotas, really statistical data tied to who they're going to hire when it comes to protected classes in order to promote some type of DEI policy. There may be some out there, but that I would say is not really who we're talking to today when we talk about how these executive orders are going to impact them. Because I think if you do have something like that, you probably need to take an immediate look at that. You're going to have more repercussions under these executive orders. The other thought I had is that when we do hiring best practices training, our focus is always on exactly what you just said, and that's nothing new. It's focus on the qualifications, bring the job description, have your policies, and avoid protected class info to the extent you can. That's the best way to do hiring. So nothing in that arena really needs to change. So let me turn it over to Jen Walrath this time and see what thoughts are on their minds with these executive orders.
Yeah, I guess I'm going to echo a little bit what others have said. I think these very clearly set out the policy viewpoints and legal viewpoints of the administration. We will start to see things trickling down because what these executive orders really do is tell government agencies certain tasks to perform to start bringing things in line with what the orders say. But at the end of the day, the orders also say that, the law of Title VII and other federal laws that are in the EEO sphere are the applicable law. So if you are operating your business in a way that is compliant with those laws, then you shouldn't be looking at having to make any drastic changes. Of course, monitor things and keep on top of things and whether anything changes. But I foresee some of this will end up getting teed up with the courts, and that could end up making some more significant changes or potentially something in Congress. But that's all in the potential future, right? We don't know if that's going to happen. And so right now, that's not where we are. And I guess the other thing we were talking about a little bit before we started the podcast today were things like affinity groups in organizations and whether and how those types of groups can be maintained and be continued. And maybe others have some thoughts on this, but I feel like where we landed on that was as long as your groups are inclusive and welcoming and no one in that group is getting any special privileges or preferences, then it's okay to have groups where people can come together, share ideas because they identify as being similar, like women's groups in organizations. But also if a male employee wanted to attend, to welcome that person to come to the group and participate, then those things should be fine even under the policies and goals articulated in the executive orders.
Yeah. Before we move on, Jen, did you have anything on affinity groups that come to mind?
Yes, and I'm glad we're talking about that because whether we refer to them as affinity groups or employee resource groups, they've often been designed to do just what Jennifer said, which is to bring like-minded people together so that there is that really imperative sense of belonging and mattering in the workplace, that they can share common interests. What we find most often is that people who do not necessarily identify with other members of that group also come in support. And they also come to be enlightened and to better understand some of the concerns, some of what people are facing. So I think those can stay. I don't think that, to your point, Jennifer, if they were designed such that members of that group got special treatment somehow, for instance, if there was a women's employee resource group and the women in that group were offered executive mentoring that wasn't available to other people, that might be problematic because that would be preferential treatment. And really what we're talking about in terms of inclusion is to have a level playing field. It's not about giving people preference, in most cases at least. It's simply about giving everybody a shot. And I think that remains important in workplaces. Workers are looking for fairness. all the time. And if they perceive that their employers are fair and everybody has a chance, they're more likely to stay with that employer. And that's important from a dollars and cents standpoint, also from a morale standpoint. So I think some of these things don't have to necessarily be unraveled.
And also, to your point, very quickly, employee retention, which is always good and helpful for an organization, especially if you've invested a lot of effort in training your employees and getting them really good at doing the jobs that they do.
Oh, yeah. Turnover is so expensive. So employers are always interested in holding on to their good talent. You spend so much money getting that great talent in the door, right? And really, even before you get any return on investment from that process, you've spent a lot of money. You've made a big investment. So you want to hold on to people, and you want to hold on to their institutional and historical knowledge, because once that leaves, you can't hire it back. So for all the reasons, we want people to feel included. We want them to feel that sense of belonging and mattering.
Yeah, I have a lot to say about that too. One concept is what Jen Hooft and I have talked about. A couple of days ago, we were in an HR focus group talking about issues in the workplace. And there was a general sense of just how disrupted workplaces all over the country are right now, just because of the change in administration, confusion among employees as to what's happening with the law, confusion over maybe misalignment with political views, and how dangerous that feels for employers all over because of a distrust among coworkers. My boss supported this, so I think that means that, or my coworker is supporting this initiative. I think that makes them a racist. I mean, comments like that employers are hearing and worrying about and wondering what that's going to do in terms of the culture and claims. And I think that ties into what you're saying, is this concept of how has the law changed when it comes to the laws that prohibit discrimination and harassment? And from our perspective, they really haven't. But if you are an employee who's hearing DEI executive orders or changing the law, do you understand that? And is that going to create more risk and more liability for employers? I think that's one issue. I would go back to another point that Jen Hooft was talking about, which is these basic concepts of fairness and how important those are in the workplace. We talk about that a lot in terms of risk assessment. I mean, no matter what, as an employer, you always want to be able to show that you're treating employees fairly. And that's what the respectful workplace policy, obviously your anti-harassment and anti-discrimination policies, regardless of what these executive orders say, employers need to make sure, absolutely, those policies are good, they're solid, they're updated, and they reflect Title VII, and in our state here, the Idaho Human Rights Act, and make sure your employees know discrimination is still prohibited on those bases.
Well, I was just thinking as you were talking, Pam, that we hear this all the time. Employers here in Idaho saying, well, Idaho's an at-will state, so I can fire someone for any reason, right? And we look at them and say, yeah, but it's any lawful reason. So as a matter of practice, right, to avoid risk and be compliant, it's always going to be a good idea to have what we call, right, a legitimate, non-discriminatory reason for doing what you chose to do, which really circles back to what Jen Hooft was talking about at the start of the podcast, which is if you already are an employer who has good policies, procedures, and practices in place that focus on those legitimate reasons for taking action, you are going to be in a good place. And again, keeping up to date with these things is important, but really it hasn't perhaps changed as much as one might think by reading the news or if you've even taken the time to read the orders.
Mm-hmm. Jen, any other thoughts on risk avoidance and claims, lawsuits, all that good stuff?
Yes, well, I would just agree that I hear frequently from employers, well, it's an at-will state, so I don't really have to give the person a reason for why I'm terminating. But back to Jennifer's point, it has to be a non-discriminatory reason. And frankly, if you don't offer a clear and concise reason for separating employment, people will construe it however they do. And oftentimes, if they're in the dark in terms of why their employment just ended, they can create a story saying, well, I think it was because I'm in this protected class. I think it's because I'm a woman. I think it's because of my national origin. I think it's because of something that would be protected under the law. And then you've got a claim. So even if you had a legitimate reason, if you didn't do kind of your due diligence, if you didn't give the person feedback ahead of time, if they didn't know this termination was coming, and then you didn't give them a reason, you're still going to have to defend the complaint or the claim. And as we all know, that gets expensive because I love my employment attorneys. But it's a pricey resource, and you're going to need that help. So I think it's really important to be really clear about you're being fair, and if you are coming down to a termination, to be honest, right?
Yeah. We're big fans of avoiding lawsuits at all costs. We're litigators, but we agree. You got to know the termination best practices, the documentation, and the fairness. There's a lot of people out there speculating, will we see an uptick in reverse discrimination claims? I think 6 months from now, it'll be interesting to see if that's evolving in the way that we think it might. And what we know from those executive orders is there's now a False Claims Act whistleblower claim, a private right of action that was detailed in that. What does that mean? We have no idea. I think it's too soon to say, but anytime you have some type of whistleblower claim that's available, in our experience on a local level, and even thinking more about the broader concept of retaliation, those claims are always dangerous, always somewhat easier to prove than a substantive discrimination or harassment complaint. But we don't know what those whistleblower claims are going to look like. That's something else we need to stay tuned and to watch for.
I wonder too, from the employment lawyer standpoint, right? If you would advise, because I would think you would, a good look at your policy language in your handbook around DEI, just to make sure that you're certainly complying, but that also what you're saying is what you're practicing, because that tends to be problematic sometimes. People will say, well, can we continue with this or that? Well, what does your policy say in your handbook? Does that need editing in any way, shape, or form? And then what do your practices look like? So just making sure that because most of us would, I would say most HR practitioners, and maybe it's not fair to speak for the population, we see the value in inclusion, right? There is ample evidence to show employee engagement is higher when people feel included, when they feel like they matter, when they feel like they can come to work without covering part of who they are. And engagement matters because that signals the emotional commitment that they have to their organization. It also signals that they have a willingness to bring more than what's required to the work. So if we're not even professional dock connectors, that tends to lead to greater productivity, better morale. People have a better work experience. Along with my HR background, I have a background in applied positive psychology, and we know how important this is for human well-being. And so we're spending 8+ hours a day at work, most of us. Those should be good hours. We should have a good experience. So for all the reasons under the sun, setting it up so that people can still feel valued, that they matter regardless of personal attributes, regardless of, any of what we're talking about today, that needs to continue.
Yeah. And I'm going to answer the question, is it a good time to take a look? And I would say absolutely. I mean, we would say anyway, like every year, you should be pulling your handbook out. We saw more changes in the law in 2024 than I recall ever seeing, with Pregnant Workers Fairness Act and maybe some, confusing Department of Labor regs that kind of bounced back and forth. But the law is always changing and evolving. And even as an employer, taking that yearly look back on your policies, think about like what happened in the workplace. Did I do an investigation and have employees or witnesses who refuse to cooperate? Okay, maybe you need to add a sentence into your complaint investigation policy that says cooperation is expected as a condition of employment here. I mean, look back over the last year. What worked? What didn't work? Do you need some language in there? Was there a wage and hour issue? Something you need to clarify? I mean, I think absolutely it's a really good time to think about what's going on in the workplace and to make sure your handbook looks good. We love doing handbooks. Just kidding. We don't. And what's really funny, but we do them all the time because they're so important. What's really funny and what we've been talking about lately is I feel like every time we're in front of supervisors doing training, no one's really looking at the handbook. And I think for employers, it's a good time. Bring your handbook out, take a look, and tell your supervisors if they haven't read it, they should. I'll add that too, because it's so important for risk. Not to mention building culture, as Jennifer Hooft would probably say, but from the litigator's viewpoint to avoiding risk. Yeah, we're 1 month into the new administration, and I was seeing some info yesterday. There have already been 38 executive orders. I mean, I think we can all agree there may well be a ton of change this year. So maybe this year even a little more than usual. So important to keep your policies updated, to keep your training updated and all that good stuff. Another point that was made in a webcast I was watching yesterday was that if you feel like you have, maybe it's the affinity group that Jennifer Walrath was talking about, and you feel like your affinity group is legal and justified, maybe it's a good time to create a document kind of explaining your justification on that. It's not a bad idea if you feel like you have a policy or an initiative or a program that could be challenged, to proactively think through and maybe create some documentation as to we consider these executive orders and here's how we think our program complies and why it is lawful right now in late January 2025.
I was thinking about that when you, Pam, and you, Jennifer Hooft, were talking. It's almost like an audit. Not quite. Audit sounds like a very formal word. But to do a survey of your policies and your practices and your procedures, groups that you have, events that you host or hold for your employees, and just give them a good once-over to make sure that they are compliant with the law and do not present any special concerns under the things that are expressed in the orders.
Let me just agree with Jennifer Walrath on that. And I would say for HR professionals particularly, what we're talking about today, again, is generally baked into the way we do our work day to day, complying with the law, providing for fair and equitable treatment, making sure that compensation is administered effectively, fairly. So I think all of that can be really, really important to us. And to make sure that we're doing a good job, we should be engaging in self-audits pretty frequently. In fact, if you come upon something that gets your attention because it wasn't completed, a form wasn't completed correctly, a policy statement is out of whack, right? Pull the thread, right? I always, when I worked in corporate settings and before I was consulting, I always looked at those as great opportunities because I think all of us want to run a tight ship. We want to make sure that if we're challenged on something, we're prepared and that we've done the work to make sure things are in order.
Absolutely. we have our email blast, we have our book that just came out, and while this is not in there, we do cover the law that still is applicable here all over the U.S. So those are good options. We have EEOC that kicks out a lot of guidance. Like, that's another way you can stay on top of this. We were just talking about before we signed on how SHRM is really the Society of Human Resource Managers. If you don't have access to their database and their email blast, that's a great way to stay. They're cutting edge, coming out with content day by day on these issues. It's a great way if you're an employer to stay on top of it. So stay tuned. We'll be talking more about these executive orders undoubtedly as we get more info, guidance. Maybe we'll see court challenges. There aren't yet, but that doesn't mean we couldn't. We don't know. And so thanks for joining us. We hope to see you next week on Ground Rules. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.